discussion on a landmark judgment delivered just 2 days ago on 26th of September by the Grand Chamber of the European Court of Human Rights in the case of Yalçınkaya versus Turkey. So given numerous violations found by the court, including an Article 6 of the Convention on the Right to Fair Trial, Article 7, no punishment without law, as well as Article 11 on the freedom of assembly, and important findings by the court in reaching these violations, we believe that the Yalçınkaya case carries broad implications, not just for Yalçınkaya applicant himself, but also for the human rights and the rule of law in Turkey.
For having me, first of all. Yeah, that's a very important aspect of this decision, to highlight that there is a systemic and widespread problem of human rights issues in Turkey in terms of especially Article 6 and Article 7. What is more problematic in this sense, I believe, is that with this Article 7 infringement, the European Court of Human Rights, once again, and in the strongest term, reiterated its belief that there is no judicial independence in Turkey.
Indeed, we were satisfied and quite satisfied with the judgment, not only because the violations, Article 7, 8, first time 7, and also article about association, but the fact that the stress, even in the press release of the court, on the systemic character of these violations is, I think, very important. This is not an individual case. It's a case, and the court itself mentions that there are thousands waiting, and that the Turkish government should do and make structural changes to avoid that still hundreds of thousands are coming.
Of course, thousands, hundreds of thousands of people have been convicted on the basis of, some very well-known criteria, including ByLock, subscription to periodicals, being a member to associations. So what are some of the domestic legal avenues that those who have been impacted could make use of?
Thank you, Emre. In fact, the court states out in its judgment, so there is a judgment which relates to systemic problem, but there is two types of measures that Turkey must resort. First are individual measures, which may be reopening of the case for the Yalçınkaya, but the case is beyond that. The court clearly says that in its judgment that I'm citing, in order to avoid it having to establish similar violations in numerous cases in the future, the defects identified in the present judgment need to the extent relevant and possible to be addressed by the Turkish authorities on a larger scale, that is beyond the specific case of the present applicant. So, and the court gave a message to the government, and it says to Turkish government to draw necessary conclusions from the present judgment in respect of, but not limited to, the cases currently pending before the domestic courts. So the message is clear: the Turkish government should deal with this systemic problem.